Okay, good morning everyone. Welcome. It's very nice to see this full room of people who are interested to talk about one single provision in the law. I think we're all nerds in some way here today. So, good morning, ladies and gentlemen. My name is Martin Husselweg. I'm assistant professor at Tilburg University. My area of expertise is intellectual property law, which is, I guess, the reason why I'm here today. And I'm very delighted that we have so many people here today for this unique event. And as you all know, for the last couple of years, we had this turbulent debate about copyright and digital single market, and that's not going to go away completely, but we have a political decision that was made, and we have a law that was adopted, and now that's something that we need to implement to make the digital single market happen and to make the digital single market to work. So obviously, we all know that people here in the debate, we're on different sides of the debate, but I think at this point it's not important anymore, because I guess what is important is to implement this law in a way that that makes the digital single market happen. And if we look at Article 17 and we'll look at the outcome, I think there's one thing that probably all of us will agree on. It's highly complicated legal text with many recitals, adding meaning to Article 17, with Article 17 interacting with other provisions of the law, sometimes in more clear, sometimes in less clear way, and that's all what we need to clarify. And the reason why we need to clarify this is because without legal certainty, we cannot build the digital single market, and the conflicting national implementations won't be to the benefit of citizens or authors or the economy at large. So, what is our goal today? And when I say our goal, I'm also speaking on behalf of Martin Kretschmer, who will arrive in 10 minutes because he just flew in this morning, who is organizing this event with me together. And our goal here today is to analyze the legal text, look at the different parts of Article 17, look at the options, analyze them, look at the modalities, pros and cons, and not decide. Because of course decision is up to the member states. We just want to flag what the options are, what the pitfalls are, what the open issues are, so that member states can make their own informed choices. And that's essentially our goal here today. So this is why academics try to organize something like this with completely only their own shirts, meaning no industry funding or anything else. Okay, I won't waste any more of your precious time, and I will immediately segue to our first panel, which I'll also chair. So our first panel, as you could see from the program, will deal with general issues. And so what I'll do is first introduce you who we have on the panel. I'll state the rules, and then I'll give a little bit of an overview myself with some takes, and then we'll quickly go through our speakers and the debate. Okay, so who do we have on the first panel? There's a slight change from the program. We only have 5 speakers on the first panel, myself included. We have Professor Marie-Christine Jansen from the University of Leuven. We have Professor Jan Noordeman from the Humboldt University on the academic side, and from the industry we have Tobias Holzmüller, General Counsel at GEMA, and Cedric Manara, Head of Copyright at Google. So this will be our first panel. Now a little bit about the rules. So what we want to do is to have a quick round of statements, 5 minutes each speaker. After that, we have a half an hour debate here at a round table, and then we open it to the audience. So the last 20 minutes, we hope, will be dedicated to questions from the audience, so feel free to think about the questions that you can ask. Okay, so with this, let me share some observations and overview of this panel from my own side. So the first panel is about what it is and who is the target of the provision? And that's, of course, at the core, because we need to first define which services fall under the definition. And, of course, everyone reading Article 17 realizes it's not only a maze of definitions, it's also a maze of carve-outs, and it's additional maze of recitals that sometimes add additional meaning. And we have to sort of read all of that against the backdrop of existing case law. And we all know here in this room, probably people on the street not really, but people in this room know that Court of Justice was having some fun with Article 3 of the InfoSoc Directive over the last years, developing case law in several directions. And in particular, two directions have developed. One direction you would consider more typical communication to the public cases, and another direction of cases where previously would be dealt with under the secondary liability scenarios in the national law. So this other strand of case law, which I call recommunication of unauthorized communication, which are sort of GS Media, Filmspelle, and the Pirate Bay, these cases build a different type of tests, arguably, in the case law. Now, what we need to figure out is how Article 17 will interact with this. And this will come down to what Article 17 is. And this is what I hope we'll also hear from our speakers today. Because politically, we'll know that the goal was to clarify. So this is the political goal, at least the one that is proclaimed, that is to clarify. But the fact that you now call it clarification doesn't necessarily have legal meaning, because we need to figure out what it is in legal terms. And I see three ways how to look at it. Article 17 can be seen as an extension of Article 3 of the InfoSoc Directive, where essentially we have some sort of a legal presumption that if Article 17 definition is fulfilled, then we're dealing with the communication to the public in the meaning of Article 3 with its own conditions and liability mitigation mechanism. Second option is to look at Article 17 as a completely self-standing right, as a different right that is called communication to the public, but it's communication to the public only in the name. So let's call it sui generis exclusive right, with some tweaks. And the third way how to look at it is Article 17 is just a liability mitigation mechanism. So it doesn't extend Article 3 in any way, and it's still being dependent on the scope as defined by Article 3. So that would mean that essentially Article 3 case law on the InfoSoc Directive still would define when Article 17 would kick in as a possible litigation mechanism. Now, from the political debate and the text of the directive, it seems to me that the last option is almost impossible to argue. I think it's almost impossible to argue that 17 is still linked to Article 3 and that the Court of Justice should actually test this criteria. In other words, I don't think it's really the case that if, in the pending case of Gemma versus YouTube, if the court would say this is not communication to the public, that would mean that Article 17 doesn't apply. To the contrary, I think political will is clearly embodied in Article 17 saying if the court would say that, still Article 17 would essentially act as an extension. The question is what that really will mean and what it will do, and we'll probably hear from the speakers what they think of this, what their views are on this. But before I give them floor, I want to just say one last thing. When we look at the recitals, there are two other points that I would like to point out. And those are sort of definitional carve-outs in the recital. First is the fact that 17 is not meant to cover copyright piracy facilitating services. And it's kind of understandable that that's the case. So the idea is that a Pirate Bay shouldn't be covered by Article 17, not to be able to benefit from the liability mitigation mechanism. But it's interesting to think about how that will be operationalized, because there's nothing in the text of the directive and there's nothing in the case law of the court ever saying and distinguishing these type of services. So we will have to see whether that will essentially be introduced as an additional definitional boundary in the national implementations, which might not necessarily be a bad idea. And there are some ideas how to do that, for instance, link into the intent, inducement, etc. But that's an open question. Second thing is the recital talking about definition serving only definition of services that compete for the same audience. And I think this is quite interesting because it again doesn't come up with in the definition, but it's something that member states should probably consider because there could be cases where Article 17, perhaps in political terms, wasn't intended to be applied, but on the face of it, if you look at all the requirements, the services would fall in there. and unless you use the substitution logic, for instance, I don't know, web hosting services, then perhaps you would have a hard time saying that they are not covered. So these are some rough ideas from my side. We can deepen then. And I would suggest that now we start with Professor Marie-Christine Jansen as our lady on the panel, please.
Oh. Thank you, Martin. Okay, that works. So I'm representing the academic side. That means people are always looking at us, and you are going to explain to us what it is about. I can already tell you all these questions, I don't have the answer. Just as you, I'm coming here and hope to learn from this day, and I would congratulate the organizers because this is very helpful for, especially for the national legislators, I think. I have not had the time to look at every word because every word counts in Article 17. I was invited, I like the first question that you raised in your long list. Actually, what is Article 7? What is it installing? A new exclusive right or not? First of all, I don't think it's a new exclusive right because that's to be looked upon from the side of the right owners. I don't think the right owners get a new exclusive right. They are, that's the meaning of Article 3 for their side remains the same. But from the side of the users, in this case the OCSSPs, you know the abbreviation by now, I hope, the online content sharing service providers, they are mainly concerned. And so if taken into account what we read in Article 17, I'm looking especially at the definition and the first part of Article 17, what is clearly not true is that what Recital 64 states, it's appropriate to clarify. This is not merely a clarification, because if it's a clarification, I could suggest my legislator, you don't need to implement anything in the definition of communication to the public. That's probably not going to be playing on the safe side. Is it then really not merely clarifying what exists? It's not a new right. I'm not yet tempted to admit it's a new right. I would say for now, for me, it's a hybrid or obscure creature in the sense of a special type of liability that is now attached to Article 3. So Article 3 remains in place, but it has two types of liability. There is a strict liability that we know under the copyright regime, and there is now a new type of liability that we will add to the copyright regime. We had already this type of secondary liability, but not in the copyright regime. And for a certain type of users, we will import that from secondary liability field to primary liability field. I think there were better ways to implement it, but we're not going to discuss the real details of the text. Now, what brings me to the conclusion, or to provisional conclusion, that this is not merely Article 3, this is something new, being albeit not a new right. I have a lot of bullets that I take from the text. First of all, the first part of Article 17 says, for the purpose of this directive, this is an act of communication to the public. It does not say for the OCSSPs that it is within the scope of Article 3. It just says for the purpose of this directive, this is an act of communication to the public. Whereas if they talk of acts of the users, that are included, of course, users that upload the content on the platforms, they always state this is uses within the scope of Article 3, acts of communication within the scope of Article 3, but not when they talk about the platforms. Secondly, the liability or the whole regime, the act of communication to the public qualification, applies only in respect of content uploaded by users. So for these OCSSPs, their own conduct is not included in this special type of liability. So there are two regimes that we have to divide. Thirdly, this, as Martin has already mentioned, the carve-out of the safe harbor of Article 14. It will not apply to the platforms, whereas it will apply to their own activities. What makes it different from the current Article 3? If we apply the current version of Article 3, then we have the carve-out of Article 14. Now for the new act of communication to the public performed by the platforms, there is not a carve-out of Article 14. That is what is explicitly confirmed. On the other hand, if we look at the fourth part of Article 17, that's sort of a comparable Article 14 regime with own wording, because you get there the notice and take down, it's now a notice and stay down. So it's a sort of Article 14 that is on the one hand excluded, but on the other hand it's imported in Article 17, but in a different way. So again, we have a different situation for the mere Article 3 situations, the general acts of communication to the public, and the acts that we are now discussing. And then most important argument, of course, why is this a special type of liability under Article 3? Because we have particular defenses that only can be raised by the platforms, so the whole mechanism of the fourth part with the filtering obligations and the best efforts and so on. This is specific defense that the platforms can invoke, which is not available at all for any other person, organization that would be liable for an act of communication to the public. Then some other minor issues. When we look at the definition, this qualification of act of communication to the public is only for the platforms if there is a profit-making nature. Now, if you know, we all know the case law of the Court of Justice. Whether or not there is an act of communication to the public, we have the essential criteria, communication to the public, and then we have complementary criteria, that's the profit-making nature. So that's not an essential criteria. Here again, it becomes an essential criterion. So there are so many differences, and I'm afraid I'm consumed my 5 minutes, that bring me to the conclusion this is not merely Article 3, not really a new exclusive right, but it's a hybrid creature of liability that is infused into Article 3 for only a special group of persons, legal persons.
Thank you very much. This is great. So let's continue straight away with Jan Noordeman.
Yes, maybe I can take the mic. Does it work? Yes. Thank you so much, Martin, for inviting me to this really exciting conference. And I think, you know, it may be a little nerdy to only talk one day, to only talk about Article 17, but in our specialized world, especially in law, I think what it really needs is people that know what they talk about. So I think I very much welcome this conference to really get into the details. And I also love the first panel, especially the headline, what is it? Yeah? What is it? What is this alien kind of, or this animal we are talking about? So let me try to give my view on on some things that are more general, in particular on the issue that you already raised and Marie-Christine also raised. What is the relationship between Article 17 of the DSM Directive and Article 3 of the InfoSoc Directive? I think that's the major issue behind it. And before you can answer this question, I think you have to go back and ask yourself, what is the problem? Because looking at it on paper, as you, I think, Martin, have also mentioned, Article 3.1 of the InfoSoc Directive is about an exploitation right, is about communicating to the public, and it's not about liability, while Article 17 has a lot of liability language in it, as Marie-Christine has already mentioned. So what is the problem? Why do we need to clarify the relationship? And that is obviously the latest case law of the CJU, in particular in the Pirate Bay, where the CJU interpreted Article 3.1 of the InfoSoc Directive also as a liability provision for secondary liability. Yeah? Not only the classical communication to the public and how a copyright is used, but also on liability terms. And just to remind you, there are two conditions to come under communication to the public by the CJU as a platform according to the Pirate Bay case law. You need to, as a platform, deliberately intervene into the communication by others of your users. You need to play a central role. You need to play an active role in the communication of content. First condition. Second condition, you need to breach a duty of care while, when you intervene or when you play the central role. And if you look at with this case law in mind, if you look at the definition of the OCSSP, as it is called, in Article 2 of the DSM Directive, we are very close to this, because Article 2.6 DSM Directive, OCSSP definition says the platform needs to organize and promote for profit-making purposes. Organize and promote is very close to an active role, and that's where the problem comes from. So they are very close together, Article 3.1, the Pirate Bay case law, and the new Article 17. So what about the relationship? Is Article 17 a sui generis right? I would think at first glance, if you interpret it from the wording, it's probably a clear yes. If you read, for example, Article 1.2 of the DSM Directive, which says, except in cases referred to in Article 24, this directive shall leave intact and shall in no way affect existing rules, in particular Article 3.1. So it does not affect in any way Article 3.1 of the InfoSoc Directive. This is less clear, as Martin has already mentioned, from the recitals, because there the recitals are talking about an extension, of the communication to the public right. I also think that probably you cannot treat both as completely independent because of a systematic interpretation. Look at, for example, the privilege for startups that is included in Article 17. I think that is a clear indication that startups, according to the systematics of Article 17, should not come under Article 3.1, but should be treated under the special regime of Article 17. Also, users' rights. We do not know yet what are the duties under Article 3.1 in the eyes of the court, who will determine the duties. But we have pretty specific duties in Article 17 for platforms, also, for example, to provide users' rights to complain in case of an unjustified takedown. So my result would be, in this very short introduction, there are more arguments, I think, that Article 17 is a lex specialis to Article 3 of the InfoSoc Directive. So whenever you are an OCSSP caught by Article 17, you are no longer under the regime of Article 3.1. That said, everybody who's not caught by Article 3.1 who's not caught by Article 17 DSM Directive, still lives under the old regime of Article 3.1. So the Wikipedias of this world who are deliberately out of Article 17 live under the old regime of Article 3, InfoSoc Directive. The sharehosters, for example, who are deliberately out. The pirate platforms who are deliberately out live under the old Article 3.1. So my answers to your questions would really be that are kind of here, questions 1 and 2. Is Article 17 a sui generis right? I would say yes, it is, but it is not possible to apply it in addition to Article 3, but it lives in a relationship of lex specialis, so there's no application of Article 3.1 InfoSoc Directive on OCSSPs caught by Article 17 DSM Directive.
This is very fascinating. I already have tons of questions. Okay, let's proceed to our next speaker, who will be Tobias from GEMA. Tobias?
Thank you. Hello, everyone, and thank you, Martin, for the invitation. We all seem to be fascinated by the question, what is it, and how could it be qualified? I also had some views on this, and I'm trying to be as brief as possible because I think Jan Nordeman has already touched upon a few points I wanted to make. I think in general, when we ask ourselves, is this a confirmation, is this an expansion, is it maybe even a restriction of Article 3, InfoSoc Directive, we come to the very point that we don't really know what Article 3 really is when it comes to certain OC SSPs, because at the time when the directive came into force, we still don't yet know how the Court of Justice will deal with a YouTube case or with a uploaded case. We know there are two referrals from the German Bundesgerichtshof at the time, so it will be very interesting and to see how this plays out. And in the end, it's a bit premature to say now this is a clarification or an expansion or a restriction, because we don't even know what law we have to compare the directive to. Still, the point I want to make now is that it's probably not a concept as revolutionary as some people display it. My view is that it's actually very much in line with the path that the Court of Justice has taken in intermediary liability cases, and I think Martin Husavec has already pointed out some of these cases. 17.1, this has been said already, has a test that says store and give the public access to large amounts of copyrighted material. I mean, this is pretty close to the rule that the Court of Justice has set up in the GS Media, Filmspieler, and Pirate Bay cases, where they insist that the platform plays an indispensable role in giving the customers access to a work. So I think there is a stark resemblance in the two tests applied, and nothing revolutionary there. Also, the concept of one act of communication to the public and maybe two parties involved, this is nothing new to copyright law. We know this since the Effield case, and I think also the liability cases in Pirate Bay and Filmspieler never intended to say that simply because the platform is liable, the user of the platform is not liable anymore. So I think the concept of two parties and one act is familiar to copyright law, and the pass-through licensing in 17.2 tries to make the best out of this for uploaders by shifting the burden of licensing to the platform. Now, the interesting part is the further requirement that the court has, and that is the full knowledge of the consequences of their action. I think there we come really to the core of the problem, because Article 17, as you all know, is silent on knowledge, so there is no subjective criteria there. So a lot of people have said, well, this is a revolution, this is a new concept, you get rid of the concept of knowledge. I think if you look at the case law, at least in the cases of intermediary liability, the court has long understood that a specific knowledge of a work and its infringing nature is not a good determinator of liability in the digital era, because it favors basically the careless service over the more diligent ones, and in terms of automatization, the more automated the service gets, the less practical the knowledge requirement is. So I think what the court has done in the past is to develop a normative concept of abstract knowledge or even negligent ignorance, saying that it is sufficient that the users know or ought to have known that the service is used for infringing content. And when we look at the GS Media case, the court even operates with a presumption for commercial services that there is knowledge, and the presumption can be rebutted in a situation where the platform is able to prove that they have diligently tried to avoid copyright infringement. Now, to me, this looks very much like 17.4. This looks like mitigation of liability. And I know that some observers claim that 17.4 is something completely new, creates a new safe harbor, is something alien to copyright law. I don't believe that. I think it's pretty close to what the court has done before. And it is very interesting to read, if you haven't done so, the referral decision of the Bundesgerichtshof in these two cases I referred to earlier, because here the German court proceeded exactly in the way as I described. They came to the conclusion that both platforms in question play an indispensable role in giving access, and then they assess the question of knowledge on the basis of the nature of the service, of what the service has done in terms of efforts to prevent copyright infringement. So in the end, they come to different conclusions for both services concerned, but the way, how they reach this conclusion is very interesting to follow, and to me, this looks very much like 17.4. So my hypothesis at this time is, if we look at 17, it's probably not that different from the liability regime that could be developed outside the scope of the directive. And there would be indeed a funny situation where liability outside the directive is not that different from liability inside the directive. And then we come to what you've said, that probably there's nothing to implement. So I'm not believing this for a second, but I'm just trying to compare the two regimes and say that at least structure-wise, they're not that different.
Thank you. This is really, really interesting. Okay, with this, let's go quickly now to Cedric.
Thank you, Martin, and I would like to thank the two Martins for the initiative. And I confess, I think the academic voices were not heard during the debate, during the long directive debate, so I hope your voices of reason will be heard more during transposition. So thank you again for this event. So what is it? And Marie-Christine, you said hybrid creator. And I confess that when I saw your long list of questions, Martin, I was thinking of Mary Shelley's famous novel, Frankenstein, you know, where Victor Frankenstein builds a creator in his laboratory through an ambiguous method consisting of chemistry and alchemy. And I think that for those of us who've been exposed to some lawmakers, not all of them, I see some in the room, this is, you know, the kind of thing we saw. Martin, you mentioned, why is this carved out for piracy? Because at some point earlier this year, we realized that Article 17 might be going too far, so okay, let's add this. So I think it was this, you know, it was always trying to add new things here and there. In the end, what do we have? So in Frankenstein's novel, the Victor Frankenstein refers to the creation as creature, spectre, the demon, wretch, devil, thing, being, and ogre. Martin, in your presentation, you only had 3 options. It can be all of them combined also, you know. So I think it's, so what I mean here is that I find it worrying that the most advanced copyright scholars, and I see many of them in the room, are struggling to understand what really Article 17 is about, and what's the nature, what's the regime of the right of communication to the public in Article 17.1, etc., etc. So my point is really to say, well, let's not forget that behind these sophisticated questions lie very important practical problems. So what is, you know, it's a luxury to think of it in, you know, doctrinal terms, but the problem is, how do we deal with this when you're a platform? You know, what kind of risk do you want to take? And I think that this is very telling that, you know, when you just start reading Article 17 and you don't really know what it's about, it's very telling it's a shortcut to understanding how platforms will have to navigate this new legal environment and the decisions they have to make. And there are many examples, I think, in 17 of new vague requirements, untested requirements, etc., etc. And so if transposition can help reduce legal uncertainty, then it's welcome. If transposition helps clarify what all speakers highlighted, the articulation between 17 and Article 3 of the InfoSoc Directive and with the e-commerce directive, it will be welcome. Why? Because, and we'll be speaking of the scope in this panel, because when we think of 17, we always tend to think of YouTube primarily, the fact that it will apply to YouTube first, but let's not forget that it can impact a large number of platforms, small and big. And what I mean here is that some of the platforms, they have legal means, they have lawyers, they have a high tolerance for risks, and they can make decisions that will make Article 17, that will have an impact also on users and creators, where all the platforms smaller might be doing things differently. So what I mean here is that the higher the level of uncertainty, the higher you would see discrepancies in applying 17, and you could see a YouTube applying differently for another platform, etc., etc. And it's also this that's at stake. You know, when you want to have a level playing field, which was the purpose of the directive, are you really creating in it when it's based on so many uncertainties? So I will stop here, but this is really the question here behind of the all the very important questions we are raising is what's happening in practice for content uploaded by users and creators on platforms in tomorrow's world.
Thank you very much, Cedric. Okay, so I now try to pose a question to our speakers here that I think sort of is a litmus test for what it is, in my mind at least. So one of the questions that doesn't get perhaps that much attention is the question of, okay, so what happens if you violate? Is this a copyright infringement? Is this some other type of violation? And what remedies will be available? So, okay, you can imagine damages. If you understand this as an exclusive right, then it's a violation as any other. Consequences, potential damages, and an injunction. What could you get through an injunction in this case? It's a direct infringer in that situation? Or you look at it as something different, if you look at it more sort of like a adjacent obligation with a flavor of sort of a TPM, technical protection measures like, which I don't think is probably very strong here, but if you look at that, then of course the mechanism for enforcing this could be different than just copyright infringement. So I think this doctrinal qualification actually has an important consequence on how do we actually enforce this? What is the consequence of this? And I wonder what do our speakers think about that? I don't know who wants to be the first. Okay.
Very good question. I think it is a genuine exclusive right. So if you violate it, you are subject to injunction claims, damage claims, and all the other claims that the enforcement directive provides for full liability infringers. I think it's not a mere, it would be an option, at least you could think about it as a TPM, but I think the language of the provision is too clear that it is an exclusive right. Article 17 says member states shall provide that an online content sharing service provider performs an act of communication to the public. Yeah, that's pretty clear, I think, and speaks heavily against a mere TPM. It also speaks heavily against a mere privilege, what you could also think of, that it's a liability kind of privilege, what Tobias has talked about, that it's kind of for certain providers, gives them, a different regime they are liable under. There are certain elements to it, but still I think it remains a genuine exclusive right with its own liability rules. That's my idea.
I tend to agree that liability is copyright liability, because I think that 17.1 is a type of legal presumption that, as Jan Nordeman has said, is lex specialis to Article 3. When it comes to remedies, I think it's important to highlight the importance of damages, because from a rights holder's perspective, damages are the only way to get money for uses in the past, right? That's the only way you get royalties for the times while you have been negotiating, while you have been talking to platforms, while you have been trying to find these platforms. So speaking from my own experience of litigation that we have happily settled with Google, one of the main problems was that we had been discussing and arguing for a long time, and one of the questions was, how do we get money for all the time when the platform has been using our content until the moment when we have reached an agreement? And legally, the only way you get this is by having a damage claim that is, in Europe at least, calculated on a basis of adequate royalties, and not punitive damages that create an economic disaster on the side of the platform.
Just Well, we agree already on one thing. That's good. I also think there is no way to discuss around the conclusion that this is direct liability with the consequences of damages, injunctions, and so on. But with the difference, the main difference, if we compare Article 3 liability and Article 17 liability, there are many more defenses. So we will see whether it comes to damages and liability. And don't forget that there is a defense of Part 4, but there is also this part in long recital 66 that says even if there have been the best efforts and there are still unauthorized works, their liability will only relate to those specific works for which the platforms have received the relevant necessary information. So again, a practical question. In theory, there will be liability for damages, but how to distinguish between unauthorized these uses where they have been receiving the sufficient information and the ones for which there was not sufficient information. There are millions of works online. So that is going again to be the main problem. This is not a legal theoretical problem, but a practical problem because of the complicated liability regimes are going to be enormous.
Cedric?
Yes. Just a footnote to that. So on top of all the remedies you listed, there's also the question of contractual obligations. You know, what do we need to so because of the best efforts obligation, the best efforts clause and the need to get licenses, what does it mean in terms of cooperation and collaboration? How do we work with rights holders differently? And also what it means in terms of liability in our private relationship. That's in addition of what you listed.
Okay, thank you. So I think in addition to these, there's also an interesting question would be what, and I think Marie-Christine Jansen already kind of hinted to that, what the scope of an injunction would be. If you would, okay, so clearly damages would be very important, but what the scope of injunction would be. And my intuition is, and I wonder what speakers think, is that actually injunction-wise, we just get, in terms of the content, to the same content that you can get today under the 8.3 of the InfoSoc Directive, injunctions against intermediaries, with the difference that now you're not invoking as Article 8.3 injunction, but as an injunction against direct infringer. Seem to be shared? Okay, interesting. Okay, I have, of course, many other questions, and I think I can still pose a few questions to the panel here. So let's get to the scope of the right now for a second. How do you suggest that member states should actually implement this? So we have many definitions, we have carve-outs, we have recitals, and it will be, I think as it was very well illustrated by Art Norderman, it will be very important whether you are out, because this is clearly lex specialis, and I would tend to agree with that. Hence, if you are out of Article 17 situation, because of a carve-out, Article 3 InfoSoc Directive applies to you. Now, that means that determining the scope of 17 will be very crucial for regime. It can be also very crucial for user rights. Can be also very crucial for scope of exceptions and limitations that you can enjoy. We get to that in the fourth panel. So how should member states approach this? Should they take, for instance, the two things that I pointed out about copyright piracy, facilitating websites, and competing for the same audience as a separate test to the definition? How should they do this? Because there are many points in the recitals and the definitions. How should this be done? What do you think?
I've also already been reflecting a lot upon that issue. I think most of the member states have now a first part in their Copyright Act with the definitions of reproduction right and communication right to the public, Articles 2 and 3, and then a nice part on exceptions. It's hard for me to imagine that in the first, now very clear, the clear definitions that we have on communication to the public, I would not suggest to add something on of the language of Article 17 there. I think the only way that I see now is a very separate chapter that includes most of the provisions of Article 17, without prejudice to Article 1, supposedly that is the definition, but don't touch to the definition, I would say, and insert in your national law just a separate chapter, section, whatever you would call it, because otherwise that's how I see one of the possibilities.
Yeah, that's an interesting question, Marie-Christine. Where would you put it into your Copyright Act, especially in regimes like, for example, the German one, where I'm from, where you have a clear distinction in the law between the right, the exploitation right that you use, communication to the public, and the liability for, full liability, injunction liability, you name it. So where do you put it? Because it has both elements. It has, it's a communication to the public, but it's also got liability. That said, my first thought would be that probably you would have to put it close to the implementation of Article 3.1 InfoSoc directive, because according to the latest case law of the CJU, that already also has liability elements in it. That are usually not yet reflected in any of the liability sections of the Copyright Act. So probably it would be the best idea to put them, in where the communication to the public right is regulated. But it's also an idea to do a completely new section and said this is an alien, and we put it at the end of the Copyright Act as something unique.
Can I just add one more element? Something that struck me, and I forgot to mention it, we're always talking about copyright and Article 3, but the neighboring rights with their definition of communication to the public in a different directive, because in Article 3, Article 3.2, it's only about the making available right, but the general communication to the public right is another directive. And there is never a reference to that general communication to the public rights of neighboring rights owners. And that again complicates the matter in the member states, where often you have separate chapters, books on neighboring rights owners. So there again, how to implement it. I think they are supposedly these acts that the service providers are liable for now also include violation of the neighboring rights for the general. Well, that's open. Why is there no talk about article or the rental rights directive? I'm a bit struck by that.
Maybe an answer to that, not to your question, Martin, but I will go to your question afterwards. As when it comes to the new publisher's right, Article 15, if you read Article 17.1, it's about protection of works whose owners are named in Article 3.1, and in the new publisher's right, they're not named, they just get a right by reference. So I don't think Article 17.1 can actually protect publishers on the new publisher's right. Since you mentioned that, because again, they get a right that mirrors Article 3.1, but are not actually included in the list of right owners in 3.1. So I think it doesn't apply to them. But that's just to highlight the question of relationship between 17 and 3. I think publishers' rights are not included.
Yeah, but I'm not talking about publishers' rights.
But it's one of the neighboring rights, yes.
And producers.
As for your question, Martin, how member states should transpose the list of exclusions, well, if you I think it's been clear that 17 is not clear. So if you look back at the raison d'être, the reason why it was there and the impact assessment, it was really about having a level playing field. And I think that this should be what what should guide the member state. Make sure that there's a fair competition that exists between some services and others, and that should be one of the guidance principles for transposition. And the other one is really it's since the beginning it's been about users uploads. So the list, which is not limited, the list of exclusions, try to put names on services which are not, which main purpose is not to share, like Wikipedia and cloud, etc. So I think that if we had to capture the essence of the exclusion to be this, services which main purpose is to share should be included in 17, but not others. And that would be probably, I would say, a more open-ended approach to what we could be doing instead of having a closed list of services such as B2B, cloud, and things like this.
Sorry.
Yeah, this is
maybe we share this one. I think in terms of the definition of services covered, there are two decisive elements. One is the large amounts part, so there seems to be a de minimis kind of exception of which services are not covered. I think that will be difficult to assess. The text says it should be a case-by-case assessment by the judge, basically applying the law. I'm not sure that will work for the national transposition. And the other part is what Cedric has said, the purpose, or one of the main purpose part. I tend to agree that this is the logic that the directive applies here. I think the exclusions in the second part of 2.6 is merely clarifications of services that wouldn't fall under the definition in the first place, in order to, I don't know, prevent political problems from services claiming, well, they could potentially be covered. So I think that's probably not something that needs to be transposed, but rather be used to interpret the scope. When it comes to piracy services, I think we're not talking about a full exclusion from the scope of the directive here, but only from the mitigation part, if I understand correctly. So the liability part would still apply, which is also a concept that is quite similar. And here I'm referring again to this German referral decision in the uploaded example. The referring court basically said, well, if you have a high volume of abuse notices, if you know that your platform is intensely used as a piracy platform, if you have a business model that is basically supporting piracy and playing on piracy, then there's no way you can excuse yourself by saying that, well, I have taken all measures necessary to prevent copyright infringement. This being said, I don't think it really matters, because if you look at the mitigation part, I mean, best efforts to obtain a license, best efforts to take content down, I can hardly see how a piracy service would qualify to meet this test.
So what I keep hearing is, and I want to see whether that's the case, I keep hearing two things. So first is, they seem to be implicit, and that's why please let me know if you don't agree with that, implicit assumption here that member states have almost zero room for deviation here. That these are more or less completely autonomous European criteria, and for instance, for the open list of carve-outs that we have, such as, and not really a general clause, this is not really up to the member states to fill, but essentially they could as well just include the definition, and the courts should look at a directive to understand what is in and what is out, and that should in a way also answer the question whether they should deal with the recitals that sometimes try to clarify the reason why this definition is there. So that seems to be the first thing that I keep hearing from you. Do you disagree with that, or is it really that you think that this is essentially a European decision that was made, and there's almost no room for the member states, or essentially no room for member states to deviate from the list, from the definitions?
I mean, I tend to agree that the idea behind the directive is not to have 28 different implementations where services are covered in one country and not in another country. So sooner or later it will be the Court of Justice who will decide which services qualify as an OC, SSP or not. Yes.
Yeah, I tend to share this this opinion. It's probably autonomous EU law, and so it's up to the interpretation of the CJU. That said, probably the member states, especially the case law in the member states, will probably develop in detail different approaches, because the cultural approach of member states may be different to what is what is efficient. Germans are always, for example, famous to being efficient. Maybe they have a different efficiency standard than other EU countries. Yeah, I'm not sure whether that picture is true, but if you look at the airport of Berlin, for example, but it may be, there may be cultural differences that will lead in detail to differences, but it's always subject to the CJU if that will stand the test. Yeah.
Yeah. I've just checked the 10 parts of Article 17. It's only shall. I've never found may. And it's only the part on the redress mechanisms, of course, where you have some leeway, but as regards the substantial liability provisions, I don't see much.
Okay, so I think that's quite interesting. The other thing that caught my attention is what Tobias was mentioning with respect to my specific question about the copyright facilitating piracy sites. And so you seem to suggest that that particular recital 62, is about not Article 17 not being applicable, but only 17.4 B and C not being applicable. So actually 17.4 not being applicable. So you say, is the liability mitigation mechanism that we don't think it applies, but not that the liability doesn't apply. So are you saying that those sites would be covered by Article 17? Or are you just assuming that they would be covered by Article 3 of the InfoSoc directive? And that's why you say what you say. I'm just kind of curious on that statement that you have made, so I want to clarify that.
I could just check this. Yes.
You know, Martin, in practice, these sites never show up in court. You know, so it's an interesting question, but in practice.
No, I think it's in practice. I have to contradict you. In practice,
Okay.
This would help so much, because I'm a practicing lawyer as well, and I'm involved in a lot of cases that include on-purpose piracy. And if you could say they're just objective criteria, you have to be an OCSSP, and then you communicate to the public, and you do not have to show any intent or any particular active role. That makes things a lot easier than under Article 3. So it makes a difference, because Article 17 seems to be, at least on the part whether you come under Article 17, seem to be a little easier, I would say, than Article 3. We don't know yet what, because the case law has not been final yet under Article 3, but I think the concept of coming under communication to the public is clearer under 17. So it would help work against piracy if Tobias is right. Yeah.
Yeah, and just to answer your question, now I've found I must have lost recital 62 in my own paper. I think the text says that the liability exception mechanism does not apply to piracy services. This I read in a way to say 17.1 does apply, 17.4 does not apply.
And to go back to your previous question on whether member states can deviate, whether they have room of maneuver, there's also something which we may see interesting developments on the side that may impact how member states should look at, for example, the list of services that are excluded. Just last week, in its Skype out ruling, the Court of Justice said that when a feature in a service is distinct and autonomous, and it's distinct from the main service, it's a service by itself. And this language on services could have an impact on how one should understand the list of what is a service under the definition of Article 2.6. So that we might be seeing, not in copyright, but in other developments, language or developments that could also affect or change the way transposition will take place.
Okay, this is perfect because we are right on time for the questions from the audience. So I need to repeat your questions once you pose the question because we don't have a running mic that would connect to the stream. So I see our first question there and then yours in the back. Yes.
So thank you for all the presentations. They are extremely interesting. I wanted to ask you. Sorry. Introduction.
Oh yeah, could you maybe introduce yourself? Sorry.
Yes, it will be much easier. So my name is Maja Stoyanova and I work in a web hosting company. And my question is regarding the scope of the directive. I wanted to ask you, do you think that the web hosting companies are excluded from the scope? This is my question.
Okay, wonderful question.
Thank you very
I
much.
also want to hear what our speakers think.
Go ahead. Maybe I can. I'll try.
I'm not taking a question, Maya.
So-
I'm not.
So, my idea of Article 17 is that it is specifically, please Cedric, excuse me to say that is specifically designed to cover YouTube. And YouTube is a service provider that covers both hosting and accessing the material by the public and letting the public access, the uploads. So you can not only store, but you can also, watch the stuff as somebody who has not uploaded it. And if you are a mere hosting provider who does not make it, who does not give access to third parties, you're not covered. It's an and in 17, what is it, 17.1. It says store, shall provide, when it gives access, it store must, it's in the definition. Yeah, I get confused as well. It's in a definition as saying 2.6, which main purpose is to store and give access, not all. So for example, the share hosters are not covered. That's also explicitly in one of the recitals, that share hosters are not covered and cloud services only if you combine it with giving access to the public.
Yes, and absolutely read recital 62. There are more qualifications as what these platforms should be doing. Besides storing and uploading and sharing, there should be an organizational aspect, a promotional aspect to attract a larger audience by what you are doing. You should be categorizing, or either also categorizing, using targeted promotion, lots of things, and maybe the conclusion will then be negative.
So I personally, I guess I would share that I'm not sure whether specifically on this criterion, but I agree with Professor Maria Jansen as that specifically on the active organization, let's call it this way, just a shorthand, probably web hosting would not fall in. And in any case, if we would think of the recital competing for the same audience, I think that should clearly guide us that you are out. What I find interesting, though, is the example that you have brought regarding the file hoster. So you probably think of Dropbox and that kind of services, or RapidShare and those kind of services. So I guess RapidShare should be in. At least that's my that would be my understanding. Although they went bankrupt, so I don't know whether they exist yet. But still, but for Dropbox, I think it's quite interesting, and I wonder what people have to say about this here to take the hosting to another level. Because of course there's exclusion for cloud services, but at the same time it's qualified by the fact that it's not giving public access, and of course these services do have these days, sharing options. So you can share with the public, you can share with the broader set of people that would probably qualify as public. So the question, would they fall under 17 because of that? Or would they not fall because of some other requirements in the 17? Tobias.
I don't think that the mere option that you have a sharing facility in the service automatically leads to a communication to the public or to give the public access to this work. If you look at WhatsApp, for example, I mean, this is a service that is basically designed for private communication. And of course, you can open the circle of people you address your message to maybe something that goes beyond the circle of close acquaintances, friends and family, but this does not automatically lead to the fact that the service gives the public access to the content and has this as the main or one of the main purposes. So I think there is a distinctive line to be drawn between services that openly address the public and ones that have a sharing feature that could potentially be used to target a group that is larger than the private circle of friends.
Yes, to two of the speakers, to answer to Maya's question, said, well, the recital states this, the recital states that. I think what's behind your question is really about, you know, recitals don't have operative value. You know, they won't be transposed by member states. Recitals are being cited by CJU when there's a case. So I think the real question is when you're, a service where you're not entirely sure whether you're impacted, you have to make your own decision on whether you are impacted. It's your self-assessment, and then you say, okay, maybe one day before the CJU, I will have, the recital will protect me. Problem is, how do you mean? Can you litigate? Can you go up there? So this is really, what I was saying. Speaking of legal uncertainty and what it means in practice, it's really this. When you don't know. And Manaya, I know you enough, you're a good lawyer, it means that we have a problem because we don't really know what's happening here with services and what's in the scope, what's not. Yes, recitals are helpful, but still, they are not 2.6 and 17.1. So what do we do with that?
Cedric, if I just may say one sentence to that. I sometimes find it, I know that of course it's a big issue at the moment that everyone wants to know who's covered, who's not, but in all these complaints about legal uncertainty, you often hear this from services that basically have developed quite well in a regime of legal uncertainty since 2001. And I find it confusing that now suddenly legal uncertainty is the big problem for these type of services.
I wanted to comment on something else. What is interesting is that by at least the wording doesn't cover linking services that just came to my mind that only provide the links to share hosters. That usually share hosters give you the option to generate a link and then go somewhere else and publish it. So they don't seem to be covered. That said, I would think they are covered as soon as they deliberately cooperate with share hosters. And that's the reality, I think, at least in the piracy world, is that it's not by accident that you only have certain share hosters that always, appear on the linking sites with links to them. So probably you have to be a bit generous here, but that said, linking sites that completely operate completely independently of storing services are probably not caught and have to be dealt with under 3.1. And the Pirate Bay, for example, is a classical example for somebody not storing itself, but only only providing links. Yeah, I know it's not completely true in the BitTorrent world, but let's call them links they are providing. So that's interesting. Yeah.
Okay. Joris was waiting with his question.
Thanks so much.
It's wired, so we cannot take it.
Why don't you come
Can you
over
come back?
and
Can you
take
come
the
to the
microphone?
front and maybe ask to the microphone so that we cannot disconnect it because of the stream. Yeah, because of the stream.
So my question is about, lot of really excellent discussion about the scope of the rights and what is really this right about. But it seems to me that partly what has happened with Article 17 is that we are trying to tackle enforcement problems by tinkering with the scope of rights or creating new rights. And these enforcement issues, in a way, to me, it's like they are being channeled through this new dynamic of regulating issues through platforms, targeting the platforms and giving them new responsibilities. And we see that happen in a whole range of other parallel areas. You know, like at the moment the terrorism content regulation, and there's some other things to look at there. So my question would be, if you look at more from that perspective, wouldn't it make sense to look a little bit more about what Article 17 is doing to the blurring of copyright as a private law regime, creating some form of administrative regulatory framework for copyright that is specifically focusing on a few entities to do a lot of the heavy lifting. And like then, what does that mean then for thinking also for implementation of the framework? Doesn't that mean that something like paragraph 10 becomes incredibly important to look at, like what are the stakeholder discussions and the guidance of the European Commission going to result in? So.
Okay. So who would like to pick that up?
Maybe just a quick reaction. I don't think it's correct to say that Article 17 is only about enforcement. I think it's the other way around. The problem was, what is the scope of the exclusive right? And the idea was to extend the exclusive right to the platform that is basically making the profits and trying to make them, get a license and compensate the rights holders. The public focus has been very much on enforcement because later on there was this concept that there should be a way to escape from this type of exclusive right liability for instances where, for example, the rights holder is not willing to license, and then the discussion shifted to enforcement. But the basic idea behind it was never an enforcement idea; it was a licensing idea.
So if I may slightly disagree with that, because if we look at the initial proposal, there was a licensing proposal. The Commission's proposal was enforcement proposal, and what you're saying is certainly true for music, that there was always interest to license, but there are many other domains, whether in copyright or other IP rights, where the issue is enforcement. So for those areas, the interest of the right holders was in getting an enforcement regime, which is not necessarily what they get through Article 17, but just to answer Joris's question, I think yes, for music, I completely agree with you, but in other areas, not necessarily. And when it comes to the political development, I also don't think that the initial proposal was actually as pro-licensing as the law is eventually, without qualifying it good or bad. I'm just saying as in terms of the legislative history. Okay, unless someone else wants to react to that, we have another question from João. Here.
João Pedro Quintais from the EVIR in Amsterdam. So I have many questions, but since I'm speaking after, I'll just limit myself to this. I agree with Tobias that the piracy websites actually fit into 17.1 and the recital is meant to exclude the application of 17.4. But do you think, given that this is in fact a special regime that requires a shared act, an upload by the user, communication then to the public by the OCSSP, that this has any relevance for most of piracy websites that exist today that actually do not, let me quote-unquote, host content. So for piracy websites that rely on linking, on streaming of non-hosted content, we would require Court of Justice interpretation to extend the concept of the special right in 17.1 and 2 to those activities. As it stands now in the law, if you consider it a special regime, it's very hard to say on the face of it that it would apply to something like the Pirate Bay, although it's aimed at it.
Maybe you can, Tobias, you can also comment on it later, but I think, but very good question. Obviously the Pirate Bay, because it's a BitTorrent peer-to-peer website, is different from streaming piracy. Because in central streaming piracy, you usually have scenarios where the linking site closely cooperates with the shareholders. And they know each other, they talk to each other, and sometimes they're even owned by the same guys and operated by the same guys. They are just separated, for us to make the world think it's something different. And because they thought before the Pirate Bay, they thought they could get away with it, by simply separating those two activities, linking site and storing. That said, I think probably Article 17, if you interpret it a little generously, then those guys that just separate it in theory, but in reality they closely work together, or it's even the same guy that runs both, they must come under Article 17.
And just to confirm what you have said, yes, I think that hosting is an essential element of the application of 17.1. And if you don't store the content, then you're outside the scope of 17.1, then you're back in 3. And then you see what the Court of Justice makes of it. But they also decided the Pirate Bay case as they did, although they never stored the content, if I understood it correctly.
Okay, we have one more question there. Could you come to the front? Just.
Hello, good morning. Thank you for organizing this event. I have a question for Cedric.
Can you introduce yourself?
Yeah, my name is Rachel Alcala. I am from Queen Mary University.
Okay.
PhD candidate. I would like to ask about YouTube, actually, and now we're talking about that it's not so clear how to implement this Article 17. Are there any talks now about, licensing and maybe content ID to make it possible? Content ID licensing. Are you going to implement content ID to all the users? I mean, can you elaborate a little bit?
I'm sorry. This question I think is not for this panel. I think that's for later panels for prevention, unless it's about a scope and
the scope of the enforcement. Is there any thoughts about it? Have you discussed it already, or is it too early to talk about implementing Article 17?
So your question is about what technologies will be used to...
No, about the licensing scheme, because there is already licensing with the partners of Content ID.
And we have a licensing panel, so
there
let's
is
park it for the licensing panel.
Okay, so I save this question for later then.
Okay.
Okay, thank you.
So more questions on the scope and what this is from the audience?
I can answer though, just to say that I will not reveal today the compliance plans.
Okay, no surprise there. More questions? If not, I certainly have one more question. It's something that we didn't address, but I think it's quite important, and that is what we call forum shopping, just with a label here in our questions. And essentially the question is, well, here discussing and under the assumption that the internet is sort of separated by walls, and each member state is only regulating its own area, and the services can adjust for every single area. And my question is, how do you see this unfolding in practice when we get into jurisdictional competition? So one member state having an idea on how this should be enforced that is maybe different from another member state, and maybe having even a different idea whether this is a situation which he or she, as the government, should regulate in this scenario. So is the website accessible? Is that sufficient for us to say that a German copyright law is regulating this, and hence we are expecting this model that we have? Will there be some coordination? The directive, as far as I can see, doesn't really speak of those issues. How do you see this international aspect unfolding? What can we do in terms of coordination and in terms of making sure that the national approaches are respected and really addressed by the platforms in separate, and not that we end up with the strictest national implementation, assuming that it deviates, governing all the member states? How do we actually do this? How can we do this in the online space? It's more of a general question. I don't know whether you have thought about this before.
Will the situation be different in the future as what we saw now? We have Article 3 and every member state has implemented it and put in place remedies in their own way. And actually, we haven't seen many problems of these international private law aspects, I thought. So my question to you is, will it be different with Article 17 as compared with the Article 3 situation by which we are already living now? Will Article 17 have additional international questions as compared with the Article 3 situation? That's my question.
I could see some, but I don't want to bias what people will say. I can say at the end, maybe.
Yes, your question was how do member states solve this? So I'm not sure the question is for me, and I'm not sure we can solve all the problems in 17 and discrepancies. But basically, Jan mentioned earlier that there will be many cultural differences in understanding the meaning of this word and that word, and God knows there are many vague words in 17. So we will see discrepancies. I mean, they already exist, though. When you look at the application of the e-commerce directive, the Italian case law is not as favorable as others, etc. So I would say that when it comes to internet services, what we want to do is to have the same user experience across Europe. If it's not possible anymore because of the discrepancies, we'll probably need to adapt. And when it comes to licensing, in services like ours, we try to have the most comprehensive, the most global, if possible, approach to licensing. So basically, we hope that we can alleviate or we can mitigate the risks by the contractual solutions to the legal problems you're underlying.
Thank you, Cedric. Do you want to?
Yeah. I tend to agree that there will probably be some differences when it comes to licensing already. There may be collecting societies, for example, may act differently in different member states. So it will probably be difficult to roll out a pan-European service that, is kind of fulfills all the different requirements and throughout Europe, because it will be different already to do pan-European licensing deals for all the content, which may be very specific also, and also culturally very specific. So, but that said, I think services that have a global approach and that rolled out also when it comes to financing the service, like on advertisement terms, I think you have the means by coping with this also in the different member states, because you also make money, not with business models that root also in the various cultures of the member states. So I would be optimistic that plays out well.
Tobias, you have some last words?
Yeah, I think there's not much to add. I think it's a true observation that looking at the discrepancies we have in the enforcement area right now in Europe, that things can only get better. And I think that in the long run, as we said before, most of the technical terms in the directive will be interpreted by the Court of Justice in a European uniform way. And there might be a phase of large differences, but in the longer midterm run, I think that we will come to a more consistent system than what we have now.
Okay, wonderful. And on time, we are now heading for 20 minutes break. But first, please join me in thanking this excellent panel for great discussions.